The views expressed by participants in this podcast are their own and do not necessarily reflect the views of the producers, sponsors, or promoters of this production or their affiliates. Washington University in St. Louis does not directly endorse advertisers' products or services.
I'm Liberty Vittert, and this is Amended, my guide to the First Amendment. On April 19, 1775, American colonists and British soldiers had exchanged gunfire at Lexington and Concord, the first shots of what would become the Revolutionary War. So I think it's suffice to say the relationship between Britain and its American colonies were not great. Down in Philadelphia, the Second Continental Congress was trying to figure out what to do next. Some members were ready to break away from King George III and the British Empire entirely, but others weren't quite ready to start a full-blown war with the most powerful military on Earth. So they tried one last polite gesture. On July 5th, Congress sent King George III a message, a final attempt to make peace before everything spiraled totally out of control and into a full-blown war.
The purpose of the Olive Branch petition was to reconcile with King George III in England. It was actually a last-ditch effort by the Founding Fathers for peace.
That's Norm Cohen, curator at Carpel's Manuscript Museum in Santa Barbara, California.
We're actually the world's largest privately owned manuscript collection. And I'm here today to talk about the Olive Branch petition, which we have a working copy here in our collection.
It's a working copy, meaning this isn't the exact document that landed on the King's desk in London, but it is an original from that moment in history.
We have it all on one large piece of paper, oversized, and it is an impressive looking document.
The first draft of the Olive Branch petition was written by Thomas Jefferson, but the document was a little too spicy, if you will, like maybe a touch too aggressive for a document that was supposed to prevent war. So the Continental Congress handed it off to John Dickinson of Pennsylvania, who toned it way down. Dickinson was not exactly a revolutionary firebrand. In fact, he was one of the most prominent voices against declaring independence. He and other moderates believed that the real problem wasn't the king himself, but his ministers, parliament, and the people around him. The moderate thinking was if they could just petition King George directly and speak to him with the right mix of, respect, loyalty, a little flattery, he'd realize what a mess these other people in his government had made, and then everything could still be worked out. Like taxes, representation, the whole, British troops living in your house situation.
They, the Founding Fathers, represented themselves as Englishmen in a very polite manner to the King of England. They were hoping to have a dialogue, negotiations.
And you can hear that in the document itself. The language is flowing. It's almost poetic to my modern ears. The whole petition runs nearly 1,400 words. And don't worry, we're not going to recite all of it, but here are a couple of the highlights.
To the King, His Most Excellent Majesty, Most Gracious Sovereign, we pray that your royal magnanimity and benevolence may make the most favorable construction of our expressions on so uncommon an occasion.
That is a level of fawning and toting rarely heard in the modern world.
Your Majesty's ministers, persevering in their measures and proceeding to open hostilities for enforcing them, have compelled us to arm in our own defense, with a just attention to our own preservation against those artful and cruel enemies who abuse your royal confidence and authority for the purpose of effecting our destruction. We think ourselves required by indispensable obligations to Almighty God, to your Majesty, to our fellow subjects, and to ourselves, immediately to use all the means in our power not incompatible with our safety, for stopping the further effusion of blood, and for averting the impending calamities that threaten the British Empire.
So, just to translate that from 18th century English, your friends are terrible, this is getting violent, and we are very, very respectfully begging you to make it stop.
That your Majesty may enjoy a long and prosperous reign, and that your descendants may govern your dominions with honor to themselves and happiness to their subjects, is our sincere and fervent prayer.
The Olive Branch Petition was ratified on July 5th, 1775, and it was signed by a lot of names you would recognize. It's sort of like a bizarro Declaration of Independence, same cast of characters, but totally different vibe.
Among some of those people were John Hancock, Benjamin Franklin, Samuel Adams, John Adams, Thomas Jefferson, and others.
It's like a founding father all-star team, big, bold John Hancock at the bottom and everything. But instead of, we're out of here, it's more like, let's try to work this out. So in August of 1775, colonial representatives carried the petition across the Atlantic and formally presented it to Lord Dartmouth, the Secretary of State for the colonies.
Back at the time of the Olive Branch Petition, there could be a petition directly to the king, but King George III refused to read it.
Alrighty, so he wouldn't even look at it. But 2 days after the petition arrived, King George issued a response. It was not a negotiation, not even a reply to the petition that he clearly didn't read. It was the proclamation of rebellion, an assertion that the colonies were in open revolt. And basically, it was a declaration of war, the full-blown war that the Continental Congress had sent the Olive Branch Petition to avoid.
And that was used as a precedent for the Declaration of Independence itself to be written.
Yeah, because, once the king refuses to even read your petition, you stop writing polite letters and start writing breakup letters. So less than a year later, on July 4, 1776, the Continental Congress signed a very different document. No more, we, your majesty's faithful subjects. Now it's we, therefore, the representatives of the United States of America. Same writers, very different tone. And while the Olive Branch Petition is perhaps the most famous petition of the 18th century, it wasn't the colonists' only petition.
British colonists, or soon-to-be former British colonists, petitioned more than once.
That's Maggie Blackhawk, a law professor at NYU and one of the country's leading scholars on the right to petition.
Concerns about representation, concerns about access to Western lands, to Native American lands across the 1763 proclamation line. These were raised specifically within petitions that were submitted to King George.
The right to petition is kind of like the bastard stepchild of the First Amendment. It's certainly the least famous of the five rights. The one only real constitutional law nerds bring up at parties. But back then, it was a huge deal. So much so that when the Bill of Rights was being drafted, including it was really a total no-brainer.
There actually was very little debate about whether or not the right to petition would be included and what form it would take.
And it didn't just make the cut. It shaped how the government actually worked. Because unlike voting, which at the nation's founding was limited to white male landowners, petitioning the government was pretty much the main democratic tool that all people had.
It was truly open across gender, across ages, across religion, across polity.
Which means that at a time when most people couldn't vote, they could petition. So in this final episode of Amended, we're diving into this really overlooked corner of the First Amendment, the right to petition, where it comes from, how it once shaped American democracy, and how the fight over slavery dramatically changed its power. We're going to hear from a very provocative legal scholar who argues that modern lobbying might actually be distorting or violating this right. And we'll look at a 21st century attempt to bring petitioning into the digital age. Because this forgotten First Amendment right, I think it actually might be more relevant than ever.
The practice of petitioning in England dates back to the Magna Carta.
The Magna Carta, signed in 1215, one of those documents you probably studied in high school and almost definitely cannot explain now. Count me in. Don't worry, Maggie is here to help us.
About 800 years ago, there was a revolt against the king.
King John specifically, and yes, that King John, the villain from every Robin Hood story.
40 English barons claimed that they had the right to audience with King John, and the king agreed to receive them. And from that point on, the general public under Magna Carta believed that they had the right to petition the king. So to bring in a petition, a specific grievance and a request for redress, and that they would be afforded audience with the king within his court and some sort of response.
In other words, the idea that you could go directly to power, explain your complaint, and expect an answer goes back a very long way, more than 800 years. So it's no surprise that when colonists from the Continental Congress crossed the Atlantic with olive branch petition, that's what they expected.
In England, petitioning was essentially how legislatures ran. It drove the legislative agenda. So the parliament, as well as colonial legislatures, were seen as places of petitioning. And so colonial charters had in them protections for the right to petition. The first legal code in Massachusetts protected the colonists' right to petition. And that was essentially the way that colonists expressed their grievances and looked for redress. So this isn't something that follows the First Amendment. It actually predates the First Amendment.
And while petitioning was a crucial part of governance in England and its colonies, it wasn't unique to the English.
The history of petitioning globally is far more capacious, runs very deeply, and has its own forms in China, for example. And there may have even been indigenous versions and indigenous roots about the practice of petitioning in North America.
What's especially interesting about petitioning in colonial America is just how democratic it was.
It really was something that was open to almost all. Central governing roles, like the church itself, were restricted to men, but petitioning wasn't so restrictive.
And that mattered because colonial North America wasn't a union. It was a patchwork of different empires, settlers, enslaved people, Native American nations, all overlapping, colliding, coexisting. That meant that any kind of governance was messy. Petitioning became one of the few ways all of those diverse voices could actually be heard.
Anybody could petition a different government, and that process was actually open to everyone equally, including the unenfranchised. So women, African Americans, Native Americans, the foreign-born, and even children used and abused the petition process to be able to engage in lawmaking and to be heard within our legislatures.
Some of the examples are really pretty surprising, especially if your mental picture of colonial America is a bunch of rich white guys in powdered wigs making all the decisions.
So particularly, I've written about the contestation of a head tax or a flat tax that the colony of Virginia had imposed on its residents in 1769 that had exempted white women, but not Black women from the tax. So a group of Black people, Black British colonists, petitioned, and the Virginia Assembly treated their petition like it had treated all others. It reviewed it, became part of the formal record, and following review and investigation, both houses of the Assembly and the governor agreed that the request was reasonable, and they passed a law through the Virginia Assembly exempting Black women from the tax.
And given how important petitioning was to the 18th century lawmaking, it's no surprise that it made its way into the Bill of Rights with very little debate.
And so important was the process that essentially on day one, the Congress is establishing rules for petition and receiving and reviewing and responding to those petitions. So it is at the heart of what Congress is doing.
Before we go any further, I have to explain that petitioning back then wasn't anything like what you'd probably think of as petitioning today. Getting hundreds or thousands of names on an online document or a clipboard outside the grocery store is a modern practice, and it's usually symbolic. Groups and individuals who start modern petitions are usually hoping to get attention from the public or the press and I guess hopefully elected representatives. But there's no guarantee that policymakers will respond or even acknowledge them. But when the United States was starting out, petitioning wasn't just symbolic. It was a system with rules, guidelines, expectations, and really crucially, the obligation of elected officials to actually seriously consider what the petition was asking for.
At the founding of this country, you could actually walk into Congress with a document that looked like a complaint and present that petition to your member of Congress. And that member would treat that petition more like litigation in a court than the tool of mass politics that petitioning has become today. So the member would take that petition and read it on the floor of Congress, making it part of the formal record. And then it would treat that petition like a complaint. So you would get a formal hearing and a response, an investigation, and then Congress would decide whether or not to grant or deny that petition.
Petitioning wasn't seen as some kind of workaround or disruption to the legislative process. It was the legislative process.
They actually saw themselves within the Congress as doing law, drawing on precedent. You'd have petitioners arguing from earlier petitions. This was a transparent process. And so they said, well, this petition was resolved in this way.
In that sense, petitions were truly one of the most egalitarian tools in government. Not only were they open to everyone, but you didn't need massive numbers or a viral movement to be taken seriously. A well-argued petition by one person could actually make a difference.
Petitioning was much more like a court process than it was like the electoral process, where if you file a complaint and you're just one person and not a class action, you get the same process than if you are a class action and have a big group of people. The number that counts is just that there is a singular person with a grievance that is reasonable, like a complaint in a court. And in fact, many petitions, claims, pensions were singularly signed. And that was the point.
Back then, Congress dedicated the first 30 days of every session just to reading petitions from constituents. 30 whole days, not debating petitions, not tabling them, just reading them. And these weren't all grand, sweeping political demands. Sure, some of them were about big national issues, but as often as not, they were surprisingly mundane.
From those early days, petitioners submitted petitions on these big constitutional questions, in addition to the more quotidian petitions for claims and pensions, post offices and post roads. There was a mixture of both what we could think of now as petitions on private issues versus more public issues.
Which was kind of the point. Petitioning wasn't just about shaping the nation, it was about navigating daily life within it. But as time went on, one issue in particular came to dominate the practice of petitioning. And you can probably guess what it was.
The abolition of slavery was high on the list of what petitioners would petition on.
Although abolitionists did not succeed in abolishing slavery through petitions alone, that doesn't mean those petitions didn't matter. Here's an example.
1799, a petition by Absalom Jones and other free Black petitioners from Philadelphia. This petition had two frames to it. One was a petition to abolish domestic enslavement. The other was a request in this petition to further regulate the international slave trade. This petition, of course, was denied, like the other abolition petitions, for the abolition of domestic enslavement. But months after this petition, submitted in 1799, the Congress actually did further restrain and regulate the international slave trade.
To Maggie Blackhawk, this anecdote captures something essential about the power of petition. Even if it didn't achieve its biggest goal, it really could still move the needle.
I think this one moment of success, and by this particular community, helps to illustrate the strength of petitioning and the legality that was operating within the petition process.
That said, petitioning had its limits, especially for opponents of slavery, in large part because slavery was seen as a state issue, not a federal one, which gave Congress a pretty convenient excuse to not act on abolitionist petitions.
They say they don't have power to intrude upon state governments in this way, and so they deny. And any repeat petition on the same subject gets essentially pointed back to this earlier resolution and just tabled.
But in the 1830s, the abolitionist movement exploded. Newspapers like The Liberator, founded in 1831, and organizations like the American Anti-Slavery Society, founded in 1833, helped turn abolition into a truly national movement. And in Congress, a well-known, experienced member who felt very strongly about the issue, former President John Quincy Adams. After losing re-election to the presidency in 1828, Adams did something no former president has ever done before. He went back into public service as a member of the House of Representatives. Although as a congressman, Adams didn't have the same power as he had as president, he still had a voice, and he intended to use it.
For him, politics was the sphere in which the great issues of justice were worked out.
That's James Traub, a journalist and author of the book John Quincy Adams' Militant Spirit, in a 2016 interview with Brian Lamb on C-SPAN.
That's what politics meant to him. And he could not live without the fight over that. And so he very happily returned to Washington.
And while he's an ally in the House of Representatives, the abolitionists tried a new strategy.
Anti-slavery activists begin to submit petitions to Congress to end slavery in the District of Columbia, over which Congress has jurisdiction. And the petitions would say, I would like Congress to prohibit slavery in the District of Columbia, which is a federally administered district, and therefore the Congress has the power to do so.
It's an effort, a very smart litigation strategy of the abolitionists to start moving, not only to build up a pressure campaign where you get thousands of petitions, but also to move them into, we want you to look at the District of Columbia. This earlier jurisdictional argument doesn't apply to these petitions, so it's a legal fight.
At the time, the center of political power leaned heavily toward the South, thanks in no small part to the 3/5 Compromise, which allowed slave states to count enslaved people in the census, and therefore towards the number of representatives they had in the House. So most other members of Congress wanted nothing to do with these petitions, because bringing them forward would risk angering most of the powerful men in the room.
And so this became a huge drama because the South didn't want this to be debated. The South took the position, this is a question for the states. It is not a suitable question for the Congress. You cannot have a discussion about slavery.
But Adams, a former president with a very deep moral bent, didn't care. To him, the right to petition was not optional. It was sacred and a priority for Congress.
In the beginning, Adams said, look, I'm not even sympathizing with these petitions, but the fact is people have a right to petition, so I'm going to present them. The Constitution guarantees the right to petition. How can you abridge that?
And that stance threatened to upend the status quo, because up until then, occasional petitions about slavery had mostly been tolerated, as long as they didn't go anywhere. Adams changed that. He insisted they be read, considered, and debated.
Well, this is a big threat, because slaveholders said slavery is a states' rights issue. It cannot be discussed or debated in Congress. And Adams said, there's a right of petition. Of course it can be discussed and debated. So that was the clash.
And that's when the real conflict starts, because what Adams saw as a constitutional right, members of Congress from slave states saw as a direct threat. So in 1836, the pro-slavery forces changed the rules.
The slaveholders responded by doing something unprecedented. They proposed and then passed laws which stipulated that on the issue of slavery, and only on the issue of slavery, Congress would not receive petitions.
This change wasn't subtle. They created a new rule specifically designed to shut down one issue, and one issue only, slavery. It became known as the gag rule, because that's exactly what it did. It gagged Congress.
The gag rule, which in many different forms essentially said that petitions about slavery, and only about slavery, cannot be presented to Congress. And then Adams would begin like a kind of buzzing mosquito to find some way of presenting a petition that he could claim wasn't really exactly about slavery, so wasn't really covered by the gag order. And Adams was, at this point, aflame with righteous fury. He had come to conclude that slavery was an evil, and now the moment had come for him to do something about it. Well, that rule was a congressional rule which expired with each new Congress. And so that meant in each Congress there would be this huge fight. Adams and others would present these petitions. Immediately the South would respond with a proposal for a new gag rule. Then there would be a huge debate over that, and every time the South would win.
At first, Adams was fighting a pretty lonely fight. But over time, his gift for persuasion began to win people over.
He basically held the floor for weeks, and he destroyed every argument. And by the end, the pro-censure folks got 28 votes out of 200 some odd. And Adams, of course, was thrilled.
Every 2 years with each new Congress, Adams got closer and closer to breaking the gag rule.
But the debates got closer and more ferocious. And Adams, after standing alone the first couple times, he became the mentor to a whole generation of anti-slavery congressmen.
And as the fight intensified, Adams got really, really creative.
He would present a petition that wasn't from abolitionists, it was from slaves. Well, the South went crazy. How can slaves present a petition? They're not people, they're property. And so this huge thing blew up, and only then did Adams reveal that the petition from slaves was asking Congress not to ban slavery, but to preserve slavery. Well, the fact is, he knew the petition had been sent to him as a fraud in order to goad him into presenting it, and he did it on purpose. So he enraged the South, so they'd have these incredible dramas, and opposition to the gag rule built up.
And eventually, in 1844, he won. The South could no longer get enough votes to maintain the gag rule.
This is, for the forces of abolition, the first time they have ever truly defeated the South in a major battle. And so it's a tremendously important moral victory. It's an incredible vindication for Adams.
Now, listen, Adams didn't end slavery, obviously, but by defending the right to petition, he forced open something the South had worked so hard to keep shut: discourse.
That free debate over slavery is what ultimately led to the election in 1860 of an explicitly anti-slavery candidate, Abraham Lincoln, which convinced the South that it had no future in the Republic and led it to secede in the Civil War.
If you ask me, that's not bad for a forgotten First Amendment right. Now, if you look at many histories of the period, scholars often point to the fight over the gag rule as marking the beginning of the end for petitioning as a meaningful political process. But the gag rule only existed 8 years, and as Maggie Blackhawk explains, we've kind of misunderstood what happened next.
So you have shifts around procedure generally, but certain things remain the same. I don't think that the gag rule fundamentally shifted the fact that you would need to introduce petitions to the committee that has jurisdiction and expertise in that area. There were ad hoc processes set up all over the place all the time. So to see this moment as the shift that kills the formal structure of petitioning, I think is also incorrect.
Instead, she argues that something else led to the decline of petitioning as an important part of the American political process.
And it's essentially a capacity problem rather than one constitutional fight over the compromise that we tell ourselves.
As the country grew, so did everything else. The population, the scope of the federal government, the number of problems needed solving, and that meant more petitions, a lot more, which was a problem for Congress.
The institution is trying to handle the problem of this much larger, much more populated nation. They were swamped, and so they built commissions. They built out the state itself, this offload process, where the Congress, it establishes patent commissions. It establishes claims commissions. It establishes commissions to deal with pensions. And it builds out what we see now as the administrative state in response to floods of petitions that it can't handle on its own.
Some of the commissions and agencies set up in the early 20th century are still around today, like the Securities and Exchange Commission, the organization that oversees stock and bond trading. But over more than 100 years of trying to manage petitions through commissions, things had become really haphazard.
Congress does a sloppy job of it. They used federal judges. They used executive branch members to build these commissions that were essentially filled with federal officers and executive officers, but they were just the people who were there who could actually run these commissions. And then in 1946, petitioning essentially closes down.
Congress finally steps in and tries to bring some order to this chaos by passing a new law to manage it all.
The Administrative Procedure Act and the Legislative Reorganization Act were passed, and both statutes collectively restructured the petition process by formally offloading it into the Federal Tort Claims Act, so into the federal courts. And so the Congress, they actually restructured their committee system to track the agencies so they could have oversight into those agencies.
And what they create is something that still shapes how we interact with our government today. After this shift, people could still petition, but if you really wanted something to happen, you weren't going straight to Congress anymore. You were going through one of these new agencies.
And in the end, you get these big, beautiful administrative agencies. Many of them still live with us today, but we don't see them as part of Congress anymore. We've almost lost sight of that part.
So the right to petition didn't disappear. It just changed course.
There are lots of formal mechanisms now in government where people can petition, especially when you're talking about agency work, which is where most government things happen in government.
That's Dan Ortiz, a lawyer and longtime law professor at the University of Virginia.
I mean, you can petition for an agency to make a rule. You can comment on proposed rules. All that is basically a form of petitioning. And also, there's a lot of law that happens in the shadow of the petition clause.
But this kind of petitioning looks very different from what it used to be. Today, it often requires expertise and a very specialized knowledge of agencies and procedures and how to navigate the system. In other words, this isn't something you can just do anymore. You have to know how to do it. Gone are the days when a single person could walk up to Congress and present their petition and reasonably expect action, or at least listening. Now, if you want to be heard, you have to know where to go and how to play the game.
Even though the clerk still records petitions today, it still has its docket books where it records formally petitions. It goes through the practice of doing that, as it's done every year since the founding. But then they closed off private bills on those subject matters and expected them to go through the agencies instead.
And because petitioning no longer plays the same central role in politics, it rarely shows up at the Supreme Court. But every once in a while, this forgotten little corner of the First Amendment rears its head. And about a decade ago, it did just that. In a case that starts not in Washington, but in a little town near Scranton, Pennsylvania, the borough of Duryea, at the center, a chief of police named Charles Guarnieri and a relationship with the Bureau Council that had gone way, way off the rails.
The borough gave him 3 written reprimands for budget overruns and for failure to produce a written statement of his job duties, and they dismissed him for disciplinary reasons.
The chief thought his firing had not followed the proper procedure, so he filed a grievance with his union and the case went to arbitration. The arbiter didn't exactly give him a glowing review. He found that Guarnieri had engaged in misconduct, even tried to intimidate members of the council. But the chief was right, the process hadn't been followed, and I guess that mattered.
The arbitrator decided that he actually should be reinstated with pay.
Back on the job, things did not exactly improve. Over time, the borough council issued him 11 written directives. Some were small, like, use your police car only for official business, don't smoke inside the Duryea municipal building. But to Guarnieri, they didn't feel routine, they felt retaliatory, punishment for winning his job back. So he filed another grievance.
And the arbitrator ordered those directives to be clarified or rescinded. And the council then revised the directives. And then Guarnieri requested $284 for overtime, and the borough denied the overtime request. And at that point, he filed an amended complaint and sues the borough council, saying that they were retaliating both for his filing the initial grievance. And things just go downhill from there.
In his lawsuit, Guarnieri argued that his union grievance was a petition protected by the First Amendment, and that the council's actions were retaliation for exercising that right. And because this case was happening in Pennsylvania, where he lived, he had a uniquely strong shot at winning.
In the Third Circuit, which comprises Pennsylvania, New Jersey, Delaware, and the Virgin Islands, they had this special rule. They interpreted the petition clause to allow someone, public employee in particular, to file a claim if they believed that the town was punishing them for their bringing information and asking for relief from the agency. And the Third Circuit was the only federal court of appeals or state Supreme Court which held that the employee didn't have to be speaking on a matter of public concern to get relief.
Which meant that even though Guarnieri's case wasn't about some sweeping public issue, just a personal, workplace grievance, he was in exactly the right place to win. Guarnieri and his team started winning, first at the district court level and then later on appeal. At this point, things were looking pretty good for Guarnieri. He's won twice. He has precedent on his side. And that's when the case catches the attention of Dan Ortiz. Yes, the guy we have been listening to.
I was representing the University of Virginia School of Law Supreme Court Litigation Clinic. We offer this experience to students to actually handle real cases for parties before the Supreme Court. I saw this and immediately gave a call to the lawyer who had handled it for the borough, and they were possibly interested.
Ortiz believed there was a real chance that the Supreme Court would take this case.
We pointed to reasons like, well, the Third Circuit's a real outlier. The Third Circuit has taken a view which is in the minority. So chances are they got it wrong. This creates disuniformity around how federal law is applied across the nation. Public employees in Pennsylvania, New Jersey, and Delaware, and the Virgin Islands are treated differently than public employees everywhere else, that sort of thing. And we talked about why this case was a good vehicle for the court to decide the issue through.
The Supreme Court doesn't like this kind of inconsistency when federal law is being applied differently depending upon where you live. That's exactly the kind of problem the court tends to step in and resolve. And Ortiz had another reason to feel confident, because when it comes to speech, the court already had a framework in place. It's called the, quote, public concern test. Basically, for government workers, not all speech is protected, only speech that deals with issues of public importance. So Ortiz's argument was simple. If that is how the court treats speech, why should petitions be any different?
The Supreme Court had earlier decided a series of cases which were brought by public employees claiming that they were being punished for their speech. And the court had said very clearly, well, if you're bringing this as a free speech claim and you're a public employee, you have to show that you were speaking on a matter of public concern. So it was an issue about the city budget, something like that, or general city policy, race discrimination or something like that, or school policy or whatever. That was protected by the free speech clause. But if it was just a matter of ordinary workplace or employment concern, no, that wouldn't be.
And Guarnieri's complaint wasn't about some big public issue. It was a workplace dispute, which is exactly why Ortiz felt confident.
I could see there would be at least some sympathy for the borough's position among some justices on the Supreme Court.
And he was right.
We'll hear argument first this morning in Case 09-1476, the Borough of Duryea versus Guarnieri. Mr. Ortiz.
Ortiz, arguing for the Bureau of Duryea, made a very straightforward case. If public employees can turn any workplace grievance into a constitutional claim, then routine HR issues suddenly become First Amendment cases. His argument was that petitions should be treated the same way as speech and subject to the public concern test.
The petition clause, like the free speech clause, was aimed at promoting democratic self-government. Petitioning is a particular form of speech. It is speech directed to a particular audience, the government, some arm of government, some individual in government, and it is speech that has a particular purpose, asking for a change of some sort in government policy.
Eric Schnapper, arguing for Guarnieri, pushed back, saying that petitions should not be treated the same as speech.
I don't think this court is committed to the view that the petition clause and the free speech clause cover exactly the same things. In fact, emphatically, obviously they don't, because the free speech clause covers many things that the petition clause would not. This court's decisions in the antitrust area and under the National Labor Relations Act with regard to in access to the government or courts, they've always been framed solely in terms of the petition clause, not the free speech clause.
3 months later, the court issued its decision, and Ortiz's hunch paid off. In a unanimous ruling, the justices rejected Guarnieri's claims that his First Amendment rights had been violated. Here's Justice Kennedy reading from the court's opinion.
The government has a substantial interest in ensuring that all of its operations are efficient and effective. The framework used to govern speech clause claims by public employees when applied to the petition clause will protect both the interests of the government and the First Amendment right.
The Borough of Duryea was off the hook. No damages, no constitutional violation. And more importantly, the court settled the question. From that point on, petition claims, like speech, would be judged by the public concern test. Now, there was finally a single uniform rule for the entire country. As Maggie Blackhawk explained earlier, petitioning slowly shifted from something handled directly by members of Congress to something routed through various, committees and eventually agencies. And along the way, something changed.
So that statute that sloughed off much of petitioning into the administrative state, that statute protects petitioning and the right to petition. And it was seen even in the drafting of the statute as constitutional. But today, if you petition any of those agencies, many of them don't have notice and comment.
As a direct tool for driving political change, petitioning has largely faded from view. Not because that right disappeared, but because the process did.
They don't have a real process of petition that's formal and that looks anything like what the right to petition was at the founding.
And in Blackhawk's eyes, the role of petitioning has been replaced by something else.
Petitioning really closes down and lobbying takes steam in the 20th century. The lobbying system sort of floods into the vacuum of where petitioning was for how Congress functioned. And it grew. Lobbying grew in power, especially as the petition process became more difficult.
Alphabet spent more than $20 million on lobbying last year. That's more than any other U.S. company.
$396 million on healthcare lobbying this year alone. We're well on the way to shatter the pace.
There are 1,800 well-paid lobbyists representing the drug companies, including former leaders of the Republican and Democratic Party. That is why, one of the reasons why, we pay the highest prices in the world.
That last voice was Senator Bernie Sanders, one of the loudest critics of this system, who argues that this kind of moneyed influence has totally distorted the democratic process. This past year alone, lobbying spending hit a record high, with more than $4.5 billion spent trying to influence Washington.
And today, our only constitutional imagination of how to engage with our legislature is through the process that wasn't supposed to be. It's like if we had shut down courts and we set up an informal process in their place. Instead, you get lobbying in its place, and it totally distracts the institution.
While Blackhawk's work now focuses on petitioning, it was actually lobbying that led her there.
I initially came to the study of petitioning from an 11-month ethnographic study I did of Congress and congressional lobbying.
And when she asked people in that world why big money lobbying was legal, even acceptable, she kept hearing the same answer.
My participants would answer those questions by quoting the text of the petition clause of the First Amendment of the Constitution. And for anyone in the legal academy, that text has very little relevance most of the time. But within this particular community, it was scripture. And I started to become very curious about its reach and meaning.
To the lobbyists she interviewed, lobbying wasn't a distortion of the right to petition. It was a continuation of it. But that's not how Blackhawk sees it.
There's some great work on early American lobbying. That lobbying existed at the founding, but it was a circumvention of the formal petition process. It looked much more like handing the judge a bag of cash on the golf course rather than filing a complaint in a court, right? It was the circumvention of what was the formal way of engaging with the Congress.
And while the old petition system had clear rules people could follow, the new system is certainly not as clear, which makes it much harder for ordinary people to participate.
So let's just say you really do want to engage with legislative advocacy. You want to be a public that's engaged with the Congress. You have to hire a professional and go through a completely opaque form of process that has no formality. You don't know what you're going to get. You don't even know if they're going to respond to you. There's no like lobbying rules of civil procedure. And so we'd like to think of lobbying as the modern equivalent of petitioning, such that the petition right would protect lobbying in its current form. But it's quite the opposite. It is unequal, and it is far from transparent.
The best return on an investment for a company might actually be lobbying.
The Sunlight Foundation took a look at the lobbying the companies did on tax bills, and what they found is the more you lobby, the less you pay.
And in response, Blackhawk has called for a renewed emphasis on the traditional form of petitioning, updated for the 21st century.
So I have proposed a formal process of petition within the Congress. I think it needs a transparent process that has regular procedures, and that right to petition should be similarly protected within the agencies that specialize in those subject matter areas.
And her work, especially her critique of modern lobbying, has been gaining real traction in legal circles.
It was awarded a prize by the American Society for Legal History. It was seen at the time, I think, as shifting conversations entirely around questions of lobbying and petitioning. And so dislodging those, giving a deeper history of petitioning, even talking about the development of administration and the administrative state was itself seen as shifting the conversation entirely. So those papers are seen as the foundational conversation of the field about petitioning and lobbying today.
While Blackhawk is looking to revive petitioning through Congress, we're going to end our episode and our season by turning to a different branch of government, the executive branch, and a modern effort to make being heard feel a little less complicated and a little more like it used to. For centuries, the right to petition has been about one simple idea, that we can speak to power and expect to be heard. So what would it take to make that idea work today? We're going to turn to a political operative you've probably never heard of, unless you're a real politics nerd.
My name's Macon Phillips, and I've worked for Barack Obama in the first term at the White House as the Director of Digital Strategy. My experience in online politics started around 2005, working for Senator Ted Kennedy and doing petitions against the war in Iraq and doing petitions about this and that.
He would literally print out his online petitions and walk them up to the Secret Service booth at the White House gate.
So I'm pretty sure it wasn't registered, but it was like a chance for us to show a visual of that and try to complete the circle with people. It really felt like there wasn't a clear way to advocate and influence the White House.
So when he began working in the Obama White House, he started wondering if there was a way to change that.
And so I had kind of a hang up once I got on the other side of the gate of petitions being this gimmick, right? That was never actually brought to the person they were targeting, and pretty cynical when you think about it. And so our goal was to say, well, what if we offered a structured way for the public to engage with us? And I found myself in a position to influence how the Obama administration did that.
So Macon helped build something new, a dedicated section of the White House website called We the People, where anyone could submit a petition on any issue.
We the People, it was a way for people to bring things to the attention of the White House. This was a great way for us to, I think, just do better by a lot of the mass advocacy that was already out there.
We the People launched on September 22nd, 2011.
Hi, everybody. We started We the People so that you could directly petition your government on the matters you care about the most, so that you could make your voice heard.
We came up with the rules, and the rules we tried to be transparent and consistent with. And what we said was, hey, anyone can create a petition, but it's not going to be public on the site for discovery unless they meet a certain threshold of signatures, so that the burden is on the person who created it to self-organize to a certain threshold. And we had to increase those limits a few times because we just weren't, I guess we didn't know how successful it would be.
That threshold served a purpose. It filtered out petitions with little support and made sure the ones that went public actually had a constituency behind them. Once a petition hit the minimum threshold, it would become available for any visitor to the We the People website to see, read, sign, share.
And then there would be a second threshold of, if it crossed this, we would answer it. Not we would do it. I mean, that wasn't really the bargain, but we would answer it.
If a petition gets enough signatures, White House staff will review it, ensure it's sent to the appropriate policy experts, and issue an official response. In this video, we'll show you how to create a whitehouse.gov account.
More often than not, the response would come from someone in the administration who had experience on the issue.
We tried not to set the expectation that President Obama would answer everything. We had a ton of credible messengers across the administration who could speak even, I think, more specifically to some of these issues.
A petition's title should complete the sentence, "We believe the Obama administration should," clearly summarizing a federal action to be taken on an issue.
Macon Phillips saw this initiative as fitting squarely within President Obama's broader push for a more open government, one built in transparency, participation, and accountability.
I think where he got engaged with it for the first time was talking about how we were delivering on some of the open government partnership commitments that he had made around participation, and this was part of that.
5 years ago, we launched the Open Government Partnership based on a few simple principles: that governments should be more transparent, that citizens should be engaged and empowered, that those in power should serve the people, not themselves. In the years since, we've made important progress.
So it was kind of combining this new moment we were at that offered digital technology, what have you, but also these things that the president thought were really important around transparency and participation, and really trying to figure out, well, what does that actually mean in rulemaking and policy making, so forth like that.
Responses will be posted to whitehouse.gov on the petitions page and emailed to everyone who signed it. Thanks for checking out We the People. We're looking forward to hearing from you.
The site took off almost immediately, and people started creating petitions on just about everything.
Petition topics varied from serious issues like healthcare, immigration and veterans issues to less serious requests like changing the national anthem to My Little Pony's theme song. The most popular petition, a request to label the Westboro Baptist Church as a hate group.
So obviously not every petition was serious, but some of them actually led to real policy change, like your ability to unlock your cell phone and use it with any carrier. Don't take that for granted, because it almost didn't happen.
For years, cell phone unlocking was exempt from the Digital Millennium Copyright Act. But since the government has an irrational sense of fear when it comes to technological freedom and evolution, they reversed their stance, making it illegal for you to unlock a phone to use on another carrier.
The Digital Millennium Copyright Act, or the DMCA, was passed in 1998.
It allowed cell phone companies to electronically lock a device such that you had to only use that service for your piece of hardware forever.
For years, regulators carved out an exemption to the DCMA that allowed people to buy cell phones and later smartphones and other devices and use them with any mobile company, AT&T, T-Mobile, Verizon, or any other provider. But in 2013, they took that exemption away. Suddenly, your device was tied to your mobile company. When you bought a new smartphone, it was locked into service with that vendor. If you wanted to switch from AT&T to T-Mobile, you had to buy a new T-Mobile lock device. It was literally illegal to unlock your AT&T phone to make it work on T-Mobile. Unsurprisingly, consumers were not thrilled with this loss of freedom.
It was kind of messed up that basically a company could just have a setting on your phone that meant it could never work with anything else. And that was put to a very clear point in this petition.
A petition asking the Obama administration to make cell phone unlocking legal passed the 100,000 signature threshold to receive an official White House response. The first since the signature threshold was raised from 25,000 to 100,000 in January.
And what was cool is I remember being in a meeting with the FCC, which we considered an independent agency and really truly tried not to influence. And this was very much we've never thought about this issue. Okay, brief us, not me, but what is this issue? What should we say?
114,000 petition signatures from unhappy consumer activists is what it took for the White House to make a stand on a controversial ban of unlocking cell phones and other mobile devices. A White House senior advisor said Monday in an official response that consumers again should be able to unlock their cell phones without facing criminal penalties.
It took a while, but ultimately it started a conversation in Congress that passed legislation, and ultimately the cell phone unlocking legislation was passed. And now if you buy a phone from a cell phone company, you don't have to always use that cell phone company for the phone you bought.
That was part of the magic of We the People. Sometimes it made the administration aware of issues they didn't even know the public cared about.
A well-run petitions system really offers you a way to mediate, the intensity around certain issues and try to address things that a lot of people care about. And ultimately, that's something that we should all be trying to do.
Many praised the Obama administration for taking charge, including the author of the unlocking petition. He said in a statement, the White House just showed that they really do listen.
So we had a number of petitions on really serious issues. And then we also had, as you might imagine, petitions on all sorts of funny issues. And obviously having a sense of humor is a big part of being successful in online communications. And that's never been natural, I think, for the White House. But we tried to do that when we could.
Hold on, sci-fi fans. This one is for you.
A petition to build a Death Star similar to the planet-destroying space station in the sci-fi franchise Star Wars. That petition has gained over 34,000 signatures.
That's right, a Death Star, the fictional planet-destroying superweapon from Star Wars. Because apparently when people are given direct access to the White House, some people choose galactic domination.
The advocates say the Death Star would create construction jobs and strengthen our national defense if only we can figure out how to shield a certain small exhaust port just below the main port, which is a reference for all the Star Wars geeks out there.
So I went to him and I said, this is kind of a silly petition, but can we pivot and talk about space program stuff? And so we came up with this joke that was, why would we invest all this money to build a system that could be demolished with a single starfighter? And we just thought that was great. And we threw some other nerd humor in there.
The White House says building a Death Star would expand the budget deficit as construction costs over $850 quadrillion. It adds the Obama administration does not support blowing up planets and that the Death Star can easily be exploited by a starship. The White House ended its response with a quote from Darth Vader saying the ability to destroy a planet is insignificant next to the power of the Force.
But the big thing was we included a pivot that said, instead of that, we've been investing in these ways. And one of the things that we linked to was the service called Spot the Station. And that allowed people to enter in their phone number and their address. And when the U.S. space station was above them at night, they would get a text and be able to go out and see, if it was clear, the blinking lights and stuff.
And somehow this joke actually led to a win for NASA, which might be the only time the Death Star has had a positive public impact.
A year and a half, 2 years later, I ran into the NASA program manager who ran Spot the Station, and they told me they got thousands of signups. And so the upshot of that petition response is that there's a bunch of people who are running out at night looking up at the space station. And so it was a really cool way of taking a fun joke about Star Wars and turning it into some real value for that guy at NASA.
The experiment didn't last, though. As is all too common in Washington, D.C., a new administration had different priorities.
Although many of them have above 100,000 signatures, the White House hasn't responded to one since President Trump took office, according to the Washington Post.
It was not clear if the Trump administration was going to take it seriously, and so it sort of fizzled out. And I think the Biden administration, it just wasn't a priority for them, and it wasn't part of how President Biden communicated.
Macon thinks that's a real loss because for a moment there, it made ordinary people feel like they actually had a role in government.
I think it's incumbent on leaders to take an extra step to make it easier for people to feel like they can at least be heard. And I got to say, that was probably the most surprising thing taking away from this was just how much people appreciated, even when we sent them responses that were more or less no. They just appreciated the transaction of feeling like they had actually gotten a confirmation that their point of view had been heard and they heard back and exchanged something. That's the core lesson.
But there's another lesson there too, and that's that the Constitution isn't frozen in time. It can be adapted for the 21st century to new technologies, new systems, and the very online world we now live in. From, handwritten letters to the king to clicks on a website, the right to petition has always been about the same idea. The people should be able to speak, and someone in power should have to listen. At its best, America is built on one simple promise, that every voice counts. Over the course of this season, we've walked through all the 5 rights packed into those measly little 45 words of the First Amendment. And honestly, I hope you're walking away a little amazed, like me, at just how much ground they cover. We've seen how freedom of religion went from protecting Jehovah's Witnesses on street corners to a football coach taking a knee on the 50-yard line, and how the Satanic Temple is stress testing those boundaries in ways the founders could never have imagined. We traced free speech from a French art film in an Ohio cinema to George Carlin's 7 Dirty Words to AI-generated deep fakes, and watched the definition of obscene twist and turn with every generation. We saw how freedom of the press, anchored by the actual malice standard in Times v. Sullivan, empowered a real golden age of investigative journalism, and how that protection is now under more pressure than it's been in decades. We explored freedom of assembly, from neo-Nazis in Skokie to the Boy Scouts to presidential Twitter accounts, and learned that the real test of a constitutional right is whether it protects the people whose views make your skin crawl. And we ended with the right to petition, the forgotten stepchild of the First Amendment, which once drove the entire legislative process and helped crack open the national debate over slavery. Here's what strikes me most. These rights were never meant to be comfortable. They were meant to be messy and contentious and sometimes infuriating, because that's what happens when you build a country around the idea that people should be free to think, speak, gather, publish, and demand to be heard. Every single case we covered, from the Take It Down Act to the Olive Branch petition, comes back to the same fundamental tension. How do you protect freedom without letting it be weaponized? And how do you prevent harm without silencing the voices that make democracy actually work? There's no clean answer, and there never has been. But I think that's what makes the First Amendment so extraordinary. It doesn't promise us harmony. It promises us the fight. And that fight, as loud and uncomfortable and never-ending as it is, it's what keeps this experiment in self-government alive. So the next time someone tells you the First Amendment is basic, tell them they're wrong. It's actually the most complicated, most important, most American 45 words ever written. And every single one of them is worth defending. This podcast was made possible through a grant from the Frick Initiative at Washington University in St. Louis. Richard Fawal and Liberty Vittert are executive producers. Noam Osbend is senior producer, Susanna Casisa is producer, and Trevor Hook is assistant producer. This podcast was written by Noam Osbend, Olivia Jampol, Liberty Vittert, Susanna Casisa, and Richard Fawal. Audio engineers are Ismael Balderas Wong and Jonathan DeLeon. Sound design and original music composition by Ismael Balderas Wong. Stephanie DeLeon-Sick and Susanna Casisa did archival research, and Laura Krebs was our finance director.
Topica.